Judgment, often it's called a summary final judgment. It doesn't matter. The important thing is the court is going to say the mortgage is foreclosed, where we, the court, are going to sell the property and we are going to eliminate the interest of these people. And the court will set in that judgment a foreclosure sale "30 days or more from the date of that judgment." A foreclosure judgment has to set a sale more than 30 days or more in advance, so that the sale can be advertised in the newspaper, because theoretically that makes all the buyers come in to bid. Yes, sir?
I have two questions. Number one, so the IRS debt or tax lien is not the same as real estate taxes.
No,
I mean, it's not at the same level, that's what I mean.
absolutely
They're
not. Absolutely not. An IRS tax lien, as we talked about back when we discussed them, takes effect only when it's recorded. It was recorded in 2007. It's junior to 2003. IRS can be wiped out just like the judgment creditor can.
Okay.
Because their tax lien takes priority only when they record their tax lien. It could have been, it's conceivable, remarkably, that IRS's tax lien could have been for 2002 income tax return, but it doesn't matter. It's when they record their notice of tax lien.
And my second question is, how can the second mortgage sue to actually foreclose and get a foreclosure when there is a first mortgage for $300,000?
Still on there. Two things. Number one, because we're going to talk about on the punchline of all this, they can't do anything about anybody in front of them.
Right.
There is no way they can eliminate this mortgage which is in front of them, nor can they eliminate this mortgage. But as you recall from my discussion here, because they're good friends, you're still making the payments on the first mortgage anyway.
Okay. Right.
So the first mortgage is not in default.
True.
So what's your question? I'm sorry. How can they foreclose if there's a mortgage in front of them? If they're a 10th mortgage, they can foreclose against everybody behind them, but there are 9 mortgages in front of them. You can only foreclose against people behind you.
Right, but the first mortgage is backed by the property.
Yep.
How can they sell the property that is backing the first mortgage that has a higher, has precedence?
Because as you're going to see in a minute, when the property is sold, the $300,000 mortgage is still on there. It ain't going away.
I got it.
Okay?
Okay.
And that's whoever buys at the foreclosure sale is buying with a $300,000 mortgage on there.
That's like condominiums.
HOA selling. You could call the bank, we could instead of bank number 2, we could call this condo association.
Right.
Same concept. They can't eliminate mortgages in front of them.
Right.
But they can eliminate liens behind them, which is what they're doing here. Even if this were the condo association, they couldn't eliminate the mortgage in front of them, but they sure as hell can eliminate people who record after them. But nobody can eliminate the county.
That's how you buy a condo in Ocean Drive with ocean view for $20,000.
Yeah, because it has $1 million mortgage on it. Yeah, exactly. All right, let's finish this. So here's what happens. The court sets a final judgment of foreclosure that says we're going to have a foreclosure sale in 30 days. Now, realize, what we didn't talk about here is after this complaint is filed, before the final judgment of foreclosure, judgment creditor had the right to come in and try to prove they were in front of the bank. They ain't going to be able to prove it. They got recorded 4 years later. IRS gets the right to come in and say, don't you know we're IRS? And in this case, the judge is going to say, that's tough. I don't care. You recorded in 2007. Get to the end of the line. So they've all come in and bitched and moaned and said, well, why they should be in front of the bank and why this isn't fair that they're getting wiped out. Basically, that's tough. Everything is established based upon the recording order. That's the order of priority. And these people are behind the mortgage being foreclosed, so they're going to lose on this piece of property. So that's the point. That's what's going on in the 6 months between this, or actually the year between this and this, is everybody else coming in trying to say this isn't fair, we're getting screwed, and the judge saying, yeah, you are, that's too bad. Final judgment of foreclosure. They're going to have a sale in 30 days. Okay, we get to 30 days later, we have a foreclosure auction. Now, as I'm sure you know, those auctions that used to be on the courthouse steps are now done online. And people bid online just like eBay. Here's my bid, and ultimately at the end of the auction, when it's all done, whoever wins the bidding, and people are bidding money here, is going to get a certificate of sale. All that says is you won the auction. You don't have title yet. As you may recall then, we said that's the same day. And of course on that day, whoever won the auction has to bring in all his money by 2 o'clock that afternoon and put it in the clerk's hands. Whatever he bid. Whether he bid $1 million or whether he bid $20, whatever the winning bid is, gets paid to the clerk, and the clerk gives him a certificate of sale. Now, as you recall, we said that there is a 10-day statutory right of redemption in Florida. For that 10-day period, the owner still has the right to come in and pay the $150,000, but it's no longer $150,000. It now has a 1.5 years of interest, which could be, let's say this was a 10% loan, it could be $22,000 of interest. It has $7,000 of attorney's fees. It has court costs of another, what are we, 29? That's unrealistically low. $1,000 of court costs. So now this $150,000 debt is $180,000 due. The total due on that debt is now $180,000. But the owner, for the 10 days after the certificate of sale has been issued, still has the right to come in and pay the $180,000 and make all this go away. Pay the money to the court gives the money to the bidder at the auction, court gives the money to bank number 2, the bidder at the auction comes into court and gets his money back, and this whole damn thing goes away and the owner still owns it. But assuming the owner doesn't do that, and the reason you'll see in a minute, he's not going to do it, is of course because the property is only worth $400,000 now, and we'll go through the realistic economics of that in a moment. But the point is, assuming the owner does not come in and pay the full amount of the debt within 10 days, the court will issue a certificate of title. We saw one of those in our deed search, where we saw a certificate of title issued to a bidder at a sale, which is where the court transfers the title of the property to whoever was a successful bidder at the auction and had the certificate of sale. That same person then gets a certificate of title, and that person then owns the property. That's a deed, and that transfers the title to that buyer who bought it at the auction. But let's talk about what he bought. He bought a piece of property on which the seller still has an easement and on which there is a $300,000 first mortgage. So how much do you think he's going to pay? And the property is really worth $400,000. How much do you think the guy's going to pay at an auction? At most $100,000, right? If he's willing to pay full retail value and he's just dying to have the property, at most he's going to pay $100,000, but probably less. And what's he got? He's got title of the property with a $300,000 mortgage on there, with an easement outstanding in front of the seller because he couldn't eliminate that. And this is wiped out and gone because they got foreclosed out. This is wiped out and gone. However, He also has to pay the taxes, and those are probably $10,000 a year. So there's another $20,000 due of taxes. So if he's aware of that, and if he's checked it out, he's probably not going to pay 100, he's maybe going to pay 80 times. Because whoever buys it has got to pay those taxes. Realistically, that's where we end up with who's going to be the bidder at the sale. Now think about this. What is bank number 2 going to do when somebody shows up and bids? What's really the property worth? $80,000 now, right? I mean, that's, if you buy it, you're buying it with $320,000 worth of liabilities on there, right? And it's worth $400,000, so really the property is worth $80,000. So what is bank number 2 going to do at that foreclosure sale? They're probably going to end up owning. Probably. Nobody's going to bid. Think about this. How much traffic do you think this will generate for somebody, a sophisticated person, to come into court to pay a purchase price to buy this piece of property that maybe is worth $400,000, but of course everybody wants to steal it in a foreclosure sale. And once somebody's done the research and found out there's $320,000 worth of debts on there, realistically, somebody at the auction may only bid $20,000. So what is bank number 2 going to do? Bank number 2 has to think about, do we want to let the auction go through at $20,000 and all we get is $20,000? That's all we get. We, the bank, get the proceeds that are bid at the auction. That's the whole reason we're here, is to say, court, sell it and give me the money. What is the bank going to do? Well, probably the bank is going to say, nah, we don't want to let that guy buy it for 20, because all we're going to get is 20. So we, bank, will bid 25. Because any money that we bid, will we get back anyway? So the bank will say, oh, we'll bid 25. Maybe the other guy will say, okay, 30. Maybe the price will come up and get closer to the 80. But realistically, once anybody bids 80 at the sale or more, of course the bank is going to let the sale go through, because if the bank took the property back, what's it worth to the bank? 80. So financially, the bank has got a decision to make whenever a bidder, understand it, what we say basically the bank has 180 of credit to bid. Since the bank is due $180,000, since this judgment says bank is due 180, which, you know, was 150 plus interest, plus attorney's fees, plus court costs, the bank is due 180. We say basically that the bank has $180,000 of credit that it can bid. The reason it's credit is because if it puts the money in, it's getting it right back itself anyway. So frankly, the court knows that and doesn't even require the bank to put money in when it's bidding. So bank number 2 can bid up to 180 without even really having to put any money in the pot, because it's due 180. And if it put 180 in, it would get 180 of its own money back. So the point is, it's got $180,000 worth of credit that it can bid at the sale. But when the bidding gets up closer to what the property is really worth, and it's really only worth $80,000, because whoever buys it is getting it with 320 of debt on there, the bank has a decision to make. If somebody bids 50, what does the bank want to do? Does the bank want to bid 60, take the property back, and see if perhaps maybe it can sell it for more? But it may not be able to. It may own it for a couple of years. Maybe the bank will let it go through with somebody bidding 50. And if somebody bids 50 at the sale and gets it, they put the 50 in, they have 320 of debt, they've really bought the piece of property for $370,000. But maybe the bank won't let it go for that. Maybe the bank will bid all the way up to 80. But the point is, I want you to realize the economics of the value of the property are what drive this thing. If, instead of being worth $400,000, think how it would change the dynamics of this whole thing if it, instead of the property being worth $400,000 at the time of the foreclosure, think about what would happen if the property were worth $700,000. It totally changes everything then. The bank is going to sit back and wait. There's $320 of debt on there, right? And the bank is in there for $180. So there's really, up to this point, there's $500,000 of debt. And even if you add all that, there's $650 of debt. If the property is worth $700, this changes the dynamics totally of people bidding at a foreclosure sale. People who think that they can buy a $700,000 property out of foreclosure for $180,000, even if they realize that there's $320 of other debt on there, which is $500, it still would be a great bid on this piece of property to bid $550. If somebody bid $550 at the sale, think of what would happen. Somebody bids $550 at the sale. Forgive me.
No.
They're not going to bid $550. They're going to bid on top of $320, minus $320. If somebody bids $220 at the sale, think how happy the bank is going to be. The bank is going to get its entire $180. And this person has bought a piece of property with, that's $230, with $320 of debt on there, by bidding at the sale $230,000. The person has gotten a piece of property for a real price of $550. If the fair market value was $700,000, the guy's done great. Somebody has saved $150,000 by buying the property out of the foreclosure sale. So all the economics of this turn on what the value of the property is. If the property is way underwater like this, then the bank usually ends up buying the thing because nobody else will bid on it.
The owner will get a surplus, though, right?
I'm sorry?
The owner will get the surplus.
And the surplus?
Right.
Here's what would happen. Here's what would happen with the surplus. If $230,000 is bid and the bank got $180, there's $50,000 of surplus, right?
The owner fights for it.
Okay. You would think, okay, great. That $50,000 should go back to the owner. But what's going to happen then? Judgment creditor's going to come running in and say, wait a minute, I'm next.
But where they
I
wiped
got
out,
the first claim. I got the first claim. Okay, here's what I skipped something that was irrelevant until we get to this argument. What these guys are going to say when they get sued in the foreclosure case, when the judgment creditor gets sued and when IRS gets sued, they will say, okay, we admit, we lose to the bank, but if there's any money left over, we're next.
That's what they can do.
So the point is, if any money in excess of the amount due the holder of the second gets paid in at the sale, yeah, theoretically the idea is to give that back to the owner, except there's some other people in line for it.
does the lender number 2, are they required, if there is excess proceeds, to let the other creditors know by law, or is that something that the creditors have to be, finding out?
I'm not sure I followed your question.
Okay, so you have another $50,000 left of proceeds. Okay, you have an overage.
Have overage, have 50,000 left over.
50,000, right?
50,000 in my job,
Right.
yeah, okay.
My question is, does the lender
Number two who foreclosed.
by law,
Uh-huh.
does he have to let the other creditors that were behind him know, hey, there was another $50,000 left, here's the money?
It's not his obligation. The lawyers for judgment creditor and IRS are going to be watching the sale too.
Gotcha.
And when that money gets paid into the clerk, they're going to come running in and saying, we're next. But it's
they-
not the
they-
job of bank number 2. Bank number 2 doesn't care about that.
But they don't go to lender number 2, they go to the court.
Right.
Oh, well, that's, yeah, the whole 230 that got bid here
Uh-huh,
gets paid into the clerk of the court.
gotcha.
That first 180 comes out and goes to the bank. The court holds the other 50 for people to fight over who gets it.
How long will the court hold that money before someone loses you know, a creditor loses, you know, like a statute of limitations
Well,
or something like that.
These people, when judgment creditor answered, there will be a provision in the judgment that will say, in this final judgment of foreclosure, here's what it's gonna say. We're gonna have an auction. And the first 180 of proceeds goes to the bank. Judgment creditor loses to the bank, but in case there's any money left over, judgment creditor gets the next 100. It's going to say, and in case there's any money left over, IRS gets the next 50. So immediately, the clerk will distribute the money based on that. And but their lawyers will have watched the sale, and they're looking for all this. And the moment that they see a penny more than 180 bid, oh, they're going to be in there looking for it. Here's the thing I want you to understand, though. A lot of people think when this happens, don't be misled by me putting an X here on these. The fact that a foreclosure has happened and that bank number 2 has said, we're in front of judgment creditor and we're in front of IRS, doesn't mean that judgment creditor and IRS are deemed paid. Judgment creditor and IRS are still after you for $150,000.
Right.
All that's happened is their lien against this piece of property has been eliminated. But it doesn't deem their debt satisfied. They're still after you on all your other pieces of property because you still owe the judgment creditor 100 and you still owe IRS 50. It's just that their lien on this piece of property has been wiped out by the foreclosure. And the bottom line, and we're going to come back to this in a minute, that I want you to learn as the lesson from all this, is that anytime there's a foreclosure can eliminate the rights of the owner and anybody junior, any junior interest, meaning recorded later. But cannot eliminate the rights, of anyone who's superior, which means who's in front of them.
And
That's what happens in a foreclosure. You can't wipe out anybody who's superior to you. You can wipe out people who are inferior to you. But I want to make sure that we understand, even though these real estate taxes are inferior in time, they are superior in dignity. And that's why, in our example, the people who are superior are Bank 1 and county times 2 for the taxes. They are in front of the lien being foreclosed. They cannot be eliminated. People who are after the lien being foreclosed can be eliminated.
Why do you say county times 2?
What?
Why do you say county times 2?
Well, that's who you pay your taxes to. The county tax collector.
Okay,
I mean, that's who sends you the bills, the county.
right.
That's who you write your check to, Broward County. That's why I'm calling them county. You can call them city, you can call them anything you want.
No,
Real
you're
estate
saying,
taxes.
no, but you're saying county times 2.
It's 2 years.
Oh, they're 2 years.
Ah,
I'm sorry, 2 years. County times 2, we have one county for the 2006 and the 2007. That's what I mean.
Gotcha.
2 years worth.
Right.
Same county, 2 years,
Right.
2 bills. Yes, okay. That's the lesson in a mortgage foreclosure, is understanding that, you remember we talked in length about that, in that whole chapter about recording priority is what establishes how everybody gets in line. Whoever records their deed first, whoever records their mortgage first, whoever records their mortgage second is second, whoever records their mortgage third is third. This, you can do the same exercise with any one of these people. IRS can come in and do a foreclosure of this length. They have a little different procedure, but they can do it. Who would IRS eliminate? Nobody except the owner, because nobody's junior to them. They can still take the property away from the owner Any of these people have a claim against the owner and they can take the property away from the owner. But IRS doesn't have anybody junior to wipe out. Our judgment creditor could come in and do it. But he couldn't name second mortgage holder. He couldn't name first mortgage holder and wipe them out. All he could do is try to wipe out IRS. But what good does that really do? You know, so the point is, when all this debt is piled on a piece of property, it creates a hell of a mess. And let's address it one step further with our concepts of what are the alternatives to foreclosure. Number one, of course, was a deed in lieu.
Sure, sir.
And the second one was a short sale. None of this stuff is going to work in a mess like this. If you had quit paying the first mortgage, and because the lender was your friend, you said, could I deed it back to the lender? Could I give you a deed in lieu? Well, the lender can't take a deed in lieu. All this other crap is still on there. There's a second mortgage and all these other things. So you can't take a deed in lieu. And how could you do a short sale? You can't do a short sale either, even if the property is only worth $250 now. You go back to this lender and say, well, let's just do a short sale and sell it for $250, and you agree to take $250 rather than $300. It's not going to work. All this other debt is on there. So the point is, when you have a mess like this, the only way to clean up the mess is a foreclosure. The alternatives to foreclosure that we talked about only work when you have a clean title and you quit right here. If this is all you got and the property is only worth $250, maybe you could do a short sale at $250. Or maybe you could do a deed in lieu. But once you pile all these other things on a piece of property, the only way to clean them up, even for the holder of the first, if you quit paying the holder of the first, the only way he can clean up the title is to wipe out everybody, including this guy,
Right.
if it's the first foreclosure. These alternatives are just out the window.
If the superiority of any of the lien holders is
If the what of any of the
the superiority,
superiority, yes,
right, is tied directly to the date of recording.
100%.
Okay.
100%, except for real estate taxes,
Okay.
because they keep
Right,
going
right,
to first.
right.
Okay, yep.
How does a bank, for example, back when they were doing 80-20 mortgages, how does the bank number one make sure that his mortgage is recorded prior to bank number two 20% mortgage?
You instruct the closing agent to make damn sure you record them in that order.
Okay.
And in addition, if you're smart, you, as the holder of the first, you require the second to put a provision in there that says, this mortgage is inferior to that certain bank loan dated, to the 80% loan.
So that even if
Even
by
if they
some
did get
mistake,
reversed, it says it's inferior.
I was wondering about that
Okay.
because
sometimes they get, that's a mistake
that's
in
the
recording.
mistake, right?
But no, that's part of, you remember the closing agent, what the closing agent's instructions are? The closing, if all this happened at the same time, if this were a $600,000 deal, it's conceivable that at the time of the closing, you had a first mortgage and a second mortgage, and you still pay $150 in cash. You know, 600, borrow 300, borrow 150, still pay another 150. Yeah, it's damn important to this guy that he gets recorded first, because if you flip him the other way, it would be a problem. So you have him provide in there that, and when we see sellers often take a purchase money second for a portion of their purchase price. If this second mortgage were the seller taking a PMM, the bank is going to require that there be a provision in there that said, this is a purchase money second mortgage subject and inferior to that certain mortgage for $300,000 recorded simultaneously herewith in favor of bank number one. To just belt and suspenders the recording order, that it's clear that it's inferior. Yes, sir, and we're going to have to quit because I know you guys are really looking forward to the exam, which starts shortly. Yes, sir.
So the first
Bank number one.
bank number one.
Yeah.
Do they have any say-so, or, I mean, if say the guy who wins the auction has inferior credit to the original lendee,
Okay.
the bank made the terms of the loan, the interest rate, and everything based on the credit of the first guy. If the winner of the auction, they have poor credit or something, do they have any rights to say, we don't want to do business with this particular guy?
Yes,
Good question.
because remember the due on sale clause? This is a sale. Let me go one step further. Be aware that in our factual scenario, that I painted the picture in order to show that the first mortgage is still in good effect and is not foreclosing, even though the second is. There is a provision in this mortgage that says any default in any inferior lien whatsoever is a default also under this mortgage and entitles this guy to accelerate and this guy to foreclose. Let me assure you that if all this is going on, this loan is going to be in foreclosure too. Even though you're trying to make the payments, it's going to say, just like they have a provision that says it's due on any sale, well, this is a sale. But they also have a provision that says any default in any other encumbrance. And it even goes on to say any encumbrance prior to or junior to us, because prior to would be real estate taxes, but they have a separate provision on real estate taxes. But they say any default in any other encumbrance is a default under this mortgage and entitles us to accelerate too. So really what's going to happen, once all this hits the fan and bank number one finds out all this is going on, even though bank number one is getting his payments, bank number one probably is not going to like all this crap going on with a piece of property. Probably bank number one is going to accelerate and send a demand letter and go ahead and foreclose. And of course, when it forecloses, it names bank number two as a defendant right after the owner to get rid of bank number two and judgment creditor and IRS, so that bank one can have this whole thing sold for, let's say, $330,000 when all of its credit is piled on. But worst case, the property is still worth $400,000, they're going to come out of this okay. We good? Okay, let's take a break for just a second and put all your stuff away if you would, and we'll do a final exam. was busy racing this, I realized I neglected one step in the mortgage foreclosure, and I apologize. Notice of lis pendens. You remember we talked about a notice of lis pendens? Whenever somebody filed a lawsuit, they record a notice in the public records. Banks' lawyers, the day they file the complaint, record in the public records a notice of lis pendens. That tells the whole world that suit has been filed against this piece of property. Don't deal with the owner. Don't take a deed from the owner. Don't give the owner a third mortgage. We're foreclosing. So, in our order of things that happens, obviously there's the acceleration notice, there's the demand letter, there's the complaint, and simultaneously with the complaint is the recording of a notice of lis pendens. Then you proceed with what happens in the case. And that notice of lis pendens has the whole style of the case in it. You know, bank to versus owner versus judgment creditor versus IRS in a recorded notice of lis pendens. Okay. Similar instructions to what we had before. In all cases, you're going to have a couple of options of getting to delete a few questions. Do so if you would. Indicate to me the ones that you don't want to answer. Obviously the ones you think you didn't do well on. But don't neglect to do that, because if you do, you're going to force me to pick for you, and the result of that's not going to be good.
You have an extra one?
What's the time frame again? 2 hours?
Yeah, I'm going to have 2 hours. I'll write the time on the board in a second when I've passed them all out. I'll have 2 hours from then, and yeah, on that clock, 5:25. That's when we quit. And put your phone down. If you would, everybody, please put away phones, computers, books, notes, everything under the table.